Good morning and welcome to the Aird & Burles LLP webinar. Today's topic is steeper fines and reporting obligations for employers. We're hitting up the occupational health and safety topic, and I'm joined today by Cynthia Sefton and David Reiter, both partners and specialists in health and safety and part of our labor and employment group here at Aird & Burles. So thank you for joining us this morning. A very important topic, and we're rolling right off the Partners in Prevention Conference, which both Cynthia and David attended last week and spoke at, and a lot of really good feedback on what employers are looking for and the kind of practical issues that they're addressing at the workplace with respect to both training and avoiding liability under the Occupational Health and Safety Act. Just a couple of quick facts for you. In 2016 and 17, the Ministry of Labor Health and Safety inspectors conducted almost 80,000 visits to more than almost 35,000 workplaces and issued more than 118,000 work orders because of non-compliance with the OHSA. And that's considerable, and we can see a real increase on that. And in 2016, the figures that we have are that the courts imposed more than $11 million in fines and entered more than 2,200 convictions against workplace parties for contraventions of the OHSA and its regulations. So this is a very timely topic and something that we want to kind of cover for our audience. And without further ado, I'm going to turn it over to Cynthia.
Good morning, and thank you for joining us. $11 million in fines in 2016. So no sensible decision can be made any longer without taking into account not only the world as it is, over $11 million, but the world as it will be. And the world as it will be means that those fines are going to go up. The agenda for today's discussion is steeper fines, limitation period for charges, notice requirements, the future, and some hopefully common sense steps to help you get through the near and far future. And David and I are going to go back and forth and perhaps even disagree on one or 2 points. So, steeper fines, then and now. For a corporation, the maximum fine has increased from $500,000 to $1,500,000 per offense, per conviction. And individuals from $25,000 to $100,000 plus jail time, again, for offense and conviction. The corporate fines bring it more into line with more modern statutes, but a significant chunk of change for companies and a significant chunk of change for individuals.
And Cynthia and I were talking about this topic and why it's important. This all comes out of Bill 177, which came into force in January, which changed the fine regime and a few other requirements which Cynthia mentioned. This is the first major overhaul of the Occupational Health and Safety Act in 28 years. I looked back last night, and in the 1978 Act, which preceded it, the fines were $25,000 for corporations and individuals. And that got changed in 1990 to try and bring it in line with reality then to $500,000 for corporations, but kept it at that for individuals. We're now seeing a major change. It's, as Cynthia mentioned, it's tripled to $1.5 million for corporations as a maximum, and it's moved to $100,000 for individuals. In terms of understanding what this means for your business, what I thought I would talk about very briefly is where we've been, because if you know where we've been, it'll help you understand where we're going. And it all starts with the case of Cottonfelts, which was a 1982 decision of our Court of Appeal here in Ontario. And what had happened was that a worker was cleaning a machine before its motion had been stopped. And that's a common problem still today for industrial facilities. So it's a lockout issue, and what happened was the management knew that the worker was not shutting down the machine when he cleaned it. His arm got sucked into the machine and had to be amputated below the elbow. The company went out and spent more than, and remember, this is 1982, spent more than $100,000 in improvements back then to their facility for safety measures. And the court adjourned the matter to give them time to make those improvements so that that could play into sentencing. The fine maximum, as I just indicated, was $25,000, and the court indicated it was going to levy a fine of $20,000. After all the improvements have been made, it still levied a fine of $12,000, and the company appealed, saying that this was just too high. It was at the 48th percentile, and the Crown themselves had only recommended a $2,000 to $3,000 fine. And the court said, no. Deterrence has got to be the key factor, and it can't just be a license for the cost of doing business. It can't be a payment for that. So the court imposed a $12,000 fine, and it went all the way up to the Court of Appeal, and it was upheld. And it set the stage for how sentencing in occupational health and safety matters went forward back from 1982 all the way to the present. It's still the seminal case. And what it talks about is you have to look at the size of the corporation, the scope of the economic activity that the corporation is involved in, the extent of the actual or potential harm, because you can have a conviction and a fine imposed even without any accident or injury happening. They look at the maximum penalty because that's the guide as to where you fall in, and the need for specific deterrence, whether this company needs to be punished specifically. We also have other ideas or principles that come into sentencing, which are the criminal law sentencing principles, which are proportionality. So the courts would look at, and this is all talked about as well in the cases, what other offenders got, and denunciation, the need to not only deter but to denounce certain conduct. And that's the baseline for how sentencing works in Ontario.
So just to follow along what David referred to, deterrence is both specific and general. And to specifically deter this particular offender from committing the same wrongful act, but also to tell industry and the public who expect a certain level of established and enforced rules that this conduct will not be tolerated. And there are other ways in which the health and safety and other regulatory statutes, environmental protection, technical standards and safety, fire code, this kind of thing, interact and intersect with criminal law. And it's important because each terrible tragedy can be investigated by a vast number of provincial authorities as well as the police. So let's talk a little bit about the intersection with criminal law, and of course the most infamous and terrible case is the swing stage tragedy which occurred in Toronto in December 2009. So just to recap the facts, there were deaths and a serious injury because a number of people went up on a swing stage to do some work on windows and balconies, and the swing stage collapsed. There were not enough lifelines, and only one was in use. Health and safety charges and criminal charges were brought against a vast array of parties, corporations, and individuals. The corporation owner pleaded guilty to 4 OHSA charges, and the criminal charges were withdrawn. The corporation pleaded guilty to criminal charges, and the project matter was tried on and convicted of criminal charges, which was a very significant issue in Canada because it was one of the first where a person in authority, a supervisor, a project matter, actually was convicted and sentenced to jail. So the company, Metron Construction, pled guilty and got it and got a penalty at trial of $200,000. The Court of Appeal said no, that's not enough. And the fact that the company really had insufficient resources to pay the fine was not determinative. And the penalty survived bankruptcy, which also is significant because you have to, if people are saying, well, I'll just go bankrupt, that may or may not be of assistance. Now, the project manager, his case went to the Court of Appeal, and earlier this year, both the conviction and sentence were upheld by the highest court in Ontario. He was the only individual tried criminally. He was convicted of 4 counts of criminal negligence causing death and 1 count of criminal negligence causing bodily harm. He was sentenced to 3.5 years in prison, which is a significant sentence, to be served concurrently. And what the courts at all levels said, the sentence has to denounce his conduct and deter others with authority over workers. Now, why that's significant is that he was not a bad actor prior to this tragedy. In fact, he was of good character, hardworking, and remorseful. He was not part of the decision for the workers to do the work. But the court said he made the decision to let the work go ahead. It was not a momentary lapse in judgment, which prior to this had been exceedingly good. In other words, the court said, despite the fact that he was a good person, which everyone listening is a good person, he put the company's interest ahead of his duty to protect the safety of the workers under his authority and failed to take reasonable steps. Now, just looking at steeper fines, it's worth pointing out that for corporations, the sentences can't be concurrent as it was with the project manager. They have to be cumulative. And this is especially significant for joint prosecutions under more than one provincial statute, as we are seeing more commonly, such as in the propane case, where there were Environmental Protection Act and health and safety charges. And it is not uncommon when a bad thing happens for these multiple investigating authorities to each lay their own charges and to prosecute at one trial. So that should be remembered. The other thing about going into the future steeper fines, remember, $500,000 to $1.5 million, $25,000 to $100,000. The absent corporate defendant can be sentenced, convicted and sentenced at a trial. So that means that the court still does its job of determining whether conviction and sentence is appropriate, but there's no one speaking up for the defendant. And this can have an impact on setting a precedent for future prosecutions. Post-incident good conduct, like David mentioned in Cottonfelts, is relevant to specific deterrence of the defendant. It shows that he, she, or it gets it, feels remorse, and takes steps to make sure that what happened doesn't happen again. But it's not relevant to general deterrence. In other words, the court still wants to send a message that this conduct will not be tolerated.
Right. And talking about the message, Cynthia mentioned that in the swing stage case, in the Metron case, that the supervisor had got in jail. And that's under the criminal negligence regime. But bringing it back to the occupational health and safety regime, we're seeing more of that now. I was looking back at the court bulletins last week, and I saw that roofing contractors, which has been a problem that's been plaguing occupational health and safety in the Ministry of Labor for a long time with falls from heights, there was a roofing contractor who had this was his 3rd conviction. It was a small operation, and he had not brought matters into compliance, and there was a 3rd incident, and he ended up getting, I think it was 30 days in jail. And it's interesting because that was as a director, which we're seeing that be used more a little bit here and there now. And director liability, officer and director liability is obviously a concern under the Act. And that also ties into how the Metron case or the swing stage case worked, because the individual owner was convicted as the director, and you would think that the supervisor who was in charge of the site would have the liability, but that director was convicted of not ensuring that training materials were in the worker's language, not ensuring that the swing stage wasn't used in excess loads or in a hazardous context, and not ensuring that training specifics were kept. So on the training records, there is a requirement that you keep dates and people who are trained and records of that, and that wasn't being done, even though the director wasn't the one delivering the training. And he got $22,500 per count, which is the 90th percentile of what the fine amount can be. And when you see that, that's the intersect between the criminal law and the occupational health and safety, and there's the steeper fines. And when we go back to Cottonfeld's, I think what we're going to see is a reflection now that the limit has been raised by percentages. And so I was looking at some fines to try and understand how things went. And if you look at Cottonfeld's, the company got a fine. It was a serious offense. There had been 100 work orders issued in the 5 months prior to the incident in Cottonfeld's. So it was a very serious offense, and it was a serious injury, and they got on the 48th percentile. And just looking back, I can see that in December 2016, there was a case in Beamsville where a reversing truck killed a worker, and they got a $290,000 fine. And that's out of a maximum of $500,000, so it's about 60% or so. In Brampton, in November of last year, there was a crane tip over, and they got a fine of $175,000. So we're seeing fine ranges in the 50 to 60, 70% range for serious incidents or fatalities. And if that was the case under the old regime, we're going to see them now become a new normal of $450,000 to $750,000 fines. And seriously egregious incidents like we had in Metron will be $1.35 million.
We're going to now talk about limitation periods for the charges under the Occupational Health and Safety Act. Again, this amendment that was made brings the OHSA more in line with other provincial regulatory statutes by introducing what's called a discoverability aspect. So what that means is, before the amendment, if the charge occurred on day one, the Ministry of Labor had 1 year from that date to lay a charge. Now, you can see why this might be problematic for the ministry, because if there's no notice given or required to be given, not given because you're supposed to, but notice wasn't given, or not required to be given, and the breach comes to the attention of the ministry or the inspector, then if it's past the year, they were out of luck. And in particular with the what I'll call repeat offenders, you can see that if they offended once, twice, or 3 times, it's likely they won't report the breach to the ministry as required. So it's now 1 year from the later of the date of the offense or the day on which the inspector becomes aware of it. So there's an offense committed, not reported, an employee, someone brings it to the attention of the ministry, or the ministry does a drop-in blitz inspection or is there for some other reason and learns about the offense, the company, the individual can now be charged within 1 year of the date that is discovered. And as I say, this is more in line with modern regulatory legislation. There may be some legal debate as to whether this is retrospective, whether it only applies from the date of the amendment. David and I have slightly different views on this, but one thing on which we both agree, very unusual for us, we agreed that you don't want to be the test case. because the ministry can and probably should push this limitation issue to the highest court, which is a very expensive proposition. So assume that the worst case for the defendant situation, and assume that it can be a year from when the inspector finds out. Also applies to continuing offenses, which David and I are familiar with, and that means that if an offense starts on day 1 and is thought to continue to day 145, the ministry will have 1 year at worst from day 145, and at best 1 year for them from when they find out to this a continuing offense.
Just one question on that, Cynthia. Is there going to be a reasonableness, do you think, application of this? Is when should they have known, or when they ought to have known, or is it strict?
Discoverability does import an element, at least in the civil side, to, when should a reasonable person in the position of the ministry have known. But we'll wait and see, but I don't think the reasonableness will necessarily play a role in the enforcement of strict liability offenses, because the change was made to allow the ministry to promote safety in the workplace. And because they can't inspect every workplace every day, that's just completely unreasonable. I don't think a reasonableness will fall into place, but undoubtedly someone will raise that as a defense. Again, you don't want to be the test case.
So we're seeing remedial legislation is going to be interpreted broadly, and they're probably going to give the ministry the benefit of the doubt, I would think, just to ensure that the message of the legislation gets through.
Absolutely.
Okay.
Yeah, I'd agree with that 100%. And Cynthia, one of the things you were saying about the discoverability component is really interesting, because we both deal with a lot of investigations. When an incident happens and the Ministry of Labor comes out and they start asking questions, and they dig into the past, pardon me, and I can think of 3 or 4 cases right offhand where prior violations that ought to have been signals, according to the ministry, to the employer are discovered. And it makes you wonder whether or not they can lay multiple charges now if they discover previous failings that weren't addressed, that didn't require notice.
Especially that's important because, of course, there doesn't need to be an injury or a death, God forbid, for there to be an offense.
Right.
There are many offenses that do not result in something bad happening, where there will be charges, and that does make sense because the object of the exercise is to prevent the bad thing from happening, not just to wait and let it happen and charge after. That doesn't bring the people back.
Interesting, though, that if you have historical offenses which weren't discovered, if that's used in sentencing down the road to say that you're already a repeat offender even though you've never been charged, if they can dig that up and use it. It's an interesting point to think about, and one of the reasons why you want to make sure that you're clean when you come to the ministry.
Right. No, and not only just as an aggravating feature in sentencing, but I'd be concerned about the possibility that they lay new charges.
Yeah, absolutely.
And you now have multiple offenses arising out of a situation where it's 5, 6, 7, 10 years later.
Yeah.
If we could talk a little bit about notice, I'm going to let David speak to this because he's more of the notice expert. But the overall approach is wait and see. David?
So the notice requirements, as the Act has it now, they're set out in 3 sections, where if you have a critical injury or a fatality, that you have to give obviously immediate notice, but then you're required to provide a report within a couple of days to the ministry. And then there are 2 other sets of circumstances, one where there's not a critical injury or fatality, but there's an injury and incident that requires hospitalization, and there are notice requirements and reporting requirements set out in that section. And then the third, which I think is the most relevant to the changes that we're seeing in the Act now, is when there are prescribed events, in other words, events that are listed in the third section, which is Section 53 of the Act, and they are set out in the regulations. So, for example, if there's contact with energized electrical equipment, you have to give notice. And there's a whole slew of these incidents that are set out, or prescribed incidents that are set out in, for example, the construction regulation. So the changes that we've seen one specific change, and they've added a section now that says if a certified Joint Health and Safety Committee member or worker representative has identified on their inspections structural inadequacies at a workplace that create a source of danger for workers, then the employer has an obligation to report. And I think, I don't know, but I expect that this probably comes out of the Elliott Mall collapse. Because there were notifications to the employer of a problem, and the ministry wasn't able to come out because they weren't notified. And in this case now, I think the ministry has, or the legislature has specifically tried to address that very problem, because as we all know, Joint Health and Safety Committees have to do, I think it's monthly inspections, and they have to report up to the employer. The other interesting change in notifications is that it allows, it's a new section 53.1 that says that there can be changes to the way in which reporting is required under any of the reporting sections. So we may now see, for example, if there's a critical injury, you have to go down a certain road, and the report, its requirements, what you have to report on, is set out in the regulations. And we may now see that you have to report it to more people, you have to provide more information, and all of this is obviously gained at the ministry collecting information so that they can investigate and prevent. But none of that's happened yet. So back to Cynthia's point about wait and see, we don't know what's coming, and we're watching for that.
And I think we're going to get to some common sense prevention, and you should plan now, but there are really things that should be corrected immediately, and if you're not sure of what is done in your workplace, and you're in a position of authority, or even if you're not, the worst offense to have brought against you is what we call a paper offense, because that is so easily corrected. Construction project notices, these notices when incidents happen, and confine these notices to what you know. Do not speculate. If at the time that you have to give the notice, you know that someone was injured or worse, you know that it occurred because they had unguarded machine or they failed to use their appropriate tie-off, say that. But do not speculate on causes of which you are not aware. Investigations of what happened take time, and it's fair to say we are investigating, or the matter is being investigated by multiple agencies, and at this time we are not aware of the conclusion or the reasons. So the other thing is, if you're going to make a change that makes things better, you can do that without being satisfied of what people like to refer to as the root cause, which I think is really a misnomer. There are usually many causes. And you can make the change in the interests of safety. It may not exactly have prevented what happened because you're not sure yet, but it's good to get credit for things that you actually do. So let's look at some common sense steps, which if you've been to any webinars that our firm and many other firms put on, I'm sure you've heard these, but take them to heart because they really are worth spending, not just money, it's not always a question of money, but the time to assess and address properly. So the first is identify and assess risks which are foreseeable. Of course, that's the rub, isn't it? What is foreseeable and what isn't? And address them one way or the other. Even if the company had all the money in the world, for as a practical matter, you can't do everything on one day. But have a plan. Remember that lawyers, prosecutors, other defense lawyers, judges, will all have the benefit of hindsight. And that means that they'll be looking at perfections.
And just to add on that, when you're trying to identify the risks that are foreseeable, which is the first step where you have to start, obviously, but one of the things that may be a practical tool that helps is the ministry puts out inspection blitz schedules and program initiatives across the province, and they've just released theirs, and we'll be speaking about that in the future. But that gives you an indication of where the trouble spots have been, whether it's in the construction or the mining or the industrial sectors, and it lets you know, because where the ministry is looking and where you should be looking. Obviously, every facility or business has its own concerns, but by looking at what the repeat problems have been, you can get help for it in advance and make sure you're not falling into the same trap that a lot of others have.
And make sure it's substance over form. People today like to have a lot of forms, and there's nothing wrong with forms and checklists, but sometimes they make the focus more on checking the boxes than actually thinking about things. So make sure it is substance. A lot of this information can be obtained free online. Ministry puts out lots of information, industry associations. It's not necessary to reinvent the wheel. So what are the steps? Train, really train. Monitor. That means really developing whatever system works for you, of being satisfied that the training is working. Supervise. Really supervise. Ask yourself, if my son, daughter, spouse, brother, sister were doing that job, what would I expect the company to do by way of supervision to ensure that that person and others are kept safe? Fix or don't fix, but make a decision. And if you don't fix immediately, but it requires fixing, have a plan to follow up that the fix gets done. And then, David, what's the last step?
It's start over, and we see that because it's a continual operation. It's a work in progress. But talking about fixing, I've seen in a few cases now, Cynthia, where people have identified the problems or the deficiencies and they triage them because there are limited resources, and that's a practical reality which businesses have to acknowledge. But if you've identified a hazard, I think that it's so important that if you can't fix it right away, that you implement a procedure or a policy and you make sure that that's trained and communicated and documented. Because, God forbid, you have an incident that you've identified the problem, someone gets seriously hurt, the ministry comes out and they said, but you knew about this. What did you do? And they said, well, we didn't have enough money. You don't want to be in the position that resources took precedence over safety ever, because that's what leads us into other regimes. So the best advice I think I can give on that, or we can give on that, is if you've identified a problem and you have to triage, make sure you deal with it in some way.
And what's really important on that issue is that, as I said, not everything can be fixed in one day, even if you have unlimited resources. So you yourself, as individuals with authority and duties under the legislation, and the business overall, has to, as David said, triage and fix the top 3, the top 5, the top 1, and have interim measures for what happens until you fix the next 3. And as David said, document. If you can't find the paper, the screen, something that says it happened, it didn't happen.
And quite importantly, and David and I have been dealing with this recently, if you've got manuals or training materials that existed, you've got to look to find them every once in a while. You have to have them in a place where you can show where they are, that they've been used, rather than in a plastic bag under a desk somewhere, because ultimately somebody may call upon you to use those to say, are they the training materials you used? Where are they? Were they implemented? And part of this is just an administrative safety check to make sure that you've got the documentation down the road. I mean, look, in many ways, we're and I've said this about employment law generally, we're kind of like divorce lawyers. right? We look at the divorce backwards rather than the marriage forwards. So if you're in front of a court and you need to prove diligence, that you need to prove you've trained, you had the manuals, you had the... You need to have that information. Assume that that's going to be the case when you're reviewing what your processes are, what your training materials are, where they are, how they're signed off, all of that.
And the funny thing that we're seeing, and we've all seen this, all three of us here, is that the employers are 90% of the time doing the work in any event.
They are, exactly.
So you might as well get credit for it by making sure you document it. It's as easy as a point and a click in some instances. One other thing that may be of assistance is to think about external auditors and new industrial, for example, the Industrial Health and Safety Association has the CORE program, the Certificate of Recognition, where they train one individual to do auditing and hazard assessment, and then they have external auditors come in and review what you've done. There's so much value in that kind of a program, whether it's a health and safety consultant or something else, but just sometimes you don't know what you don't know, and that's something Cynthia's always taught me, that you don't know what you don't know, and if you aren't able to, you have blind spots, and if you don't recognize these things, sometimes bringing a second set of eyes, an ounce of prevention is going to be worth a pound of cure.
And not knowing what you don't know is one way of looking at foreseeability. Certainly the known hazards and risks should be addressed in some way, and we're not here to tell you how to set up your shelving or how many tie-offs you need on a structure or how to guard your equipment. We're just here to tell you that you have to do it. Those are the obvious things, but also look for the things that are less obvious. And finally, to quote Winston Churchill, who had some success in his life, it's not enough that we do our best. I'm sure you're all doing your best. Sometimes we have to do what's required. And what's required is to think of these issues before the offense happens. And the future will hold much steeper fines, more investigations, and the ministry will be focused, as it should be, on the things that continue to happen, falls, guarding, that kind of thing that's been plaguing the province, the country, for so many years. Fix the things that can be fixed.
Okay. We have some time for questions now as well, and we're going to go through some questions. But the first one is, and I'll shoot this one to you, David. Is it reportable to the Ministry of Labour as a critical injury when an employee has a heart attack, loses consciousness due to low sugar, or events that happen due to personal injury, which are not work-related and confirmed as personal by the worker? Do they need to be reported to WSIB or a critical injury for loss?
So there's been a case on this type of a point. It was the case of Blue Mountains, and what happened there in that resort was that a patron, a guest, drowned in the swimming pool. And the ministry came by and they issued an order requiring the resort to provide a notice under Section 51 of the Act, which is the death or critical injury reporting requirement. And Blue Mountains appealed that, and it went to the Ontario Labour Relations Board, and they upheld it, saying, no, this is a workplace and there's been a death. Then they appealed it to the Divisional Court, and the Divisional Court agreed with the Labour Relations Board, saying, no, this is a workplace. And then it went to the Court of Appeal. And the Court of Appeal, they looked at it a little differently, and they said that there's a line of absurdity that sometimes we cross. And they said, for example, the Air Canada Centre, it's a workplace for the teams that are playing. It's a workplace for the vendors. But if somebody gets hit by a puck during the game, if it goes over the glass, over the boards, do the employers or the owners of the facility have to now shut down the game, tie everything off, call in the Ministry of Labour inspectors? That takes it to an unreasonable level, because every place at some point or another is a workplace. For example, they also used the example of highways and the OPP when there's an accident. Well, it's the OPP's workplace because they're going back and forth patrolling, but we're not going to shut down the highway if we don't need to. So the way that they dealt with it was they said you have to have a nexus, you have to have an intersect between the hazard. Is it a real hazard for a worker, the condition that caused the incident? And if it is a real hazard for your workers, then the reporting obligations kick in. If it's not, No, you don't have to. So when you ask about a heart attack, obviously, you might not know what's happening right away, and you may report it in any event, but in terms of putting in a formal report, I'm not sure that that would be required in those circumstances.
We've dealt with those kind of situations in a couple of ways. And if you're unsure about giving the notice, we've always said to err on the side of caution, because getting charged with failing to give notice is an offense you never want to commit. And so we say this is notice if notice is required. And if you're unsure, then give the notice. It's easy to do. And don't speculate. Just say this happened. It was a personal health issue. And we don't think notice is required, but just in case it is. The other thing is we did have a case where an individual had a health issue that led to a accident at the workplace, which resulted in a charge. And in that situation, there was a question as to whether the health issue was something that the employer ought to have provided for in its procedures and policies. And of course, we lawyers always say it's fact dependent. But if you're unsure and you're uncomfortable not giving the notice, because charging for failure to give notice is just a charge you don't want to see, then couch it in where we don't think notice is required, but we're giving it anyway.
And just to build on that, your point earlier about root causes and not identifying root causes, because you don't always know, you don't have medical reports back, you don't know what the underlying trigger was for the incident, it's always best to carefully craft the notice and not tie yourself one way down or another. Because the worst, well, we say this a lot, the worst thing that happens, but one of the worst things that can happen is that you've put in a notice, and you'll always see that in the disclosure package coming back at you, and it'll always be the base or the theory, part of the theory of the Crown's case. And it says we did A, B, C, and D, and then Cynthia and I, or Lorenzo and I, or the three of us come out and investigate, and suddenly we find, no, it had nothing to do with that. There was a totally another issue that none of us identified, whether it was a medical condition or the like. So you've got to be very careful in drafting your notices.
And even under the WSIA, you're required to report workplace injuries. You can still take the position that it wasn't related to the workplace or during the course of employment. But if the employee then files and you haven't filed your Form 7, you could be in trouble and you could be subject to a fine. So. Another question. If your company operates primarily under federal jurisdiction with locations in multiple provinces, does that in any way affect the level of obligation your company has in meeting the requirements defined by the Occupational Health and Safety Act regulations?
So if you are a federally regulated business, transportation across Canada, airlines, shipping, then generally speaking, you're governed by the Canada Labour Code. However, rather than be the test case for which jurisdiction should govern your workplace, we always advise to comply, if possible, with the strictest regime. That way, you're covered off, because what industry standards are, irrespective of whether you're governed by the Federal Labor Code and or the provincial regulatory statutes, industry standards are evidence of reasonableness or lack of due diligence. So there may be specific conflicts in some situations, and the best way is to try, if you can, to comply with the strictest standard, because that way you can always point to the fact that you went over and above. And by the way, these pieces of legislation are meant to be what I'll call the bottom line. neither the federal government nor the provincial authorities tell you specifically how to run your business. They tell you how they will enforce the legislation. But going in with an attitude of, I'll only do what's required, will really often, and we've all three seen this, in a point of view of saying, okay, what can we get away with? And I'm not suggesting you have to go out and spend lots of money, because very often in our experience it's allocation of time and people, not necessarily more money.
And just one more point on the split between federal and provincial. We've seen cases where the provincial ministry will take the matter to court and fight with the federal labor division over who has jurisdiction over a specific facility or a specific operation, and you do not want to be caught in the middle of that. When Cynthia was talking about comply with the higher standard, obviously that's just a great practice to take, because the courts, there's a concept called operational conflict, where the courts will look at two different statutes, usually on the same level, so both provincial or both federal, and say, as long as one doesn't say no and the other says yes, you should comply with them both. And I would think that all three of us would recommend taking that idea and applying it when you have the federal and the provincial. If one doesn't say no and the other says yes, then try to comply with both, because that will protect you, and you don't want to be the one who goes through and gets dragged along between a turf war.
And part of this is when you look at, we have some comments and questions saying, how do you avoid costly claims? Well, it's a short answer but a long process in many ways. But I think what you're hearing both Cynthia and David say is that it might be of great help for you to actually take some time, and again, it is time, not always resource, to review your processes and maybe have a third set of eyes come in. An objective, whether it's a consultant or a lawyer, and just to take some time and say, look, this is our process, this is what we're doing, where are the gaps? We talk about a gap analysis. And as lawyers and consultants, we do that for clients, where we're coming in and saying, look, you're good here, you got a little bit of work to do here. All right? And that's where you can actually effectively use that kind of advice to try to avoid liability. And it starts from the time that from how you train your supervisors and your managers, to how you document, to what you do and how you actually present your case, all the way through. That, I think, is the best overall way to do it.
Absolutely, and very good practical advice, but a word of caution. Don't invite these kind of analyses or even perform them yourselves if the three recommendations that come out of it go into that plastic bag with the manuals under someone's desk.
Good point.
And it's not that you have to implement everything that's recommended. For another day is how you can achieve that, covering it by privilege, if it is privilege, through lawyers. But you have to turn your mind to the question. And the assessor may be completely out to lunch, not if it's one of us, but there's a way of documenting, look, we've looked at that before, we even tried it, and it didn't work because. And document that. Don't just leave the recommendations dangling somewhere. They've got to be addressed, and it's fair to address them by saying we can't do everything on one day, or we tried that and it didn't work.
Fair enough. Good. So I think we're a little bit. I think we're done for the presentation for today, and we've got all those questions. If you have any other questions that you have as a follow-up, please send them in. We do make every effort to look at them and respond to them, and sometimes follow up with articles and newsletters which address them. We are going to be, as we said earlier on, there is going to be another webinar down the road. And that will be on May 29th, Blitzproofing Your Workplace, How to Survive and Thrive During an Inspection. And this is actually quite relevant at this point in time where we see that the blitz is coming and that we're in the midst of it. So from our perspective, it's very important that you understand and you get some kind of criteria on how to deal with this and how to deal with it effectively and how to deal with it in a manner in which you can avoid liability. So on behalf of David and Cynthia, I'd like to thank you for attending this morning, and we look forward to being with you again on May 29th. Thank you.